we will start this session for this month. Again, I welcome everyone once again for this month's ThePrint Charcha. This month, we are discussing the Digital Data Protection Bill Act now, which was recently passed, and we will try to decode it for all our subscribers. We have a great panel of experts with us, and we will see how and why it impacts you guys. So to start with, I'd like to introduce all our panelists to you. We have with us Ashish Aggarwal, Vice President and Head of Policy at nasscom, Kamesh Shekar, Program Manager, Data Governance and Privacy at The Dialogue, and Aparajita Bharti, Founding Member at TQH Consulting. We will try to cover as many aspects of the bill as possible, including consent, exemptions for the government, what is the data that is covered under this bill, and we generate data in huge amounts, be it booking a ticket or asking for a loan, anything that we do in online world, and most of the things that we do in offline world generate data. So we will just, and I welcome our subscribers to please send in your questions, anything that you have to ask. Our panelists are here and we will try our best to answer all your queries. So we will now begin this session, and Ashish, first I'll come to you. And to you, my question is very simple. What is digital personal data that comes under the ambit of this law, and why do we need to protect it?
Thanks, Sukita. I think we are in a digital world. So as soon as you think of data and you think of this law, it is really about data protection. So to keep it simple, I think fundamentally one can say that, there should not be a distinction between whether the data is on a piece of paper or it is in electronic form, because both should be protected. But I think it's just a kind of a look at to say that, if you want to really focus in terms of harm prevention, you are really looking at data which is actually digitized. And what you want to leave out is small businesses maybe who are still using some paper form of doing something, or let's say data which was in paper form, which is like hundreds of years old or 50 years old, and pretty much, nothing much is happening to that data in some sense. So it just leaves out those edge cases, and it's one way of looking at its ease of doing business. And second way of saying it, that it doesn't leave out much, because even that small businessman that I talked about, he's probably on WhatsApp or something else to conduct a business. So even something like a register in your society where people note down phone numbers and stuff, that in a way is excluded. But what is happening practically is that even smallest of societies and residential complexes are probably now using app for entry. So in that sense, the data is covered. So I think it's this nice balance of saying that we want to focus on stuff which is digital, where data can be used for harm if it is not regulated properly. But we don't really want to worry about stuff which is on paper, where we don't want to force people to do, take up measures where there's probably not much of harm. So that's my take on that.
So anything that is digital, from WhatsApp to our e-commerce data to these numbers that we give when we enter residential complexes, everything which is digital is recorded in electronic format will come under the ambit of this law.
Absolutely. And there is no escaping that you first collect it on paper and later digitize, and so it's not covered. No. At a point in which it gets digitized, it gets covered. So anything in electronic form, bits and bytes, which can move through internet or otherwise, is covered.
Okay. But why do we need this data to be protected? Like, we give out our phone numbers so easily. And when we say it's personal data, how do we differentiate what is personal data, what is non-personal data? And why do we need protection? Like, our phone numbers are personal and we give it out.
Yeah, sure. So data is for use, I think. But then when we say that, at the same time, if my personal data can identify me, it can give people information about me. And I don't want this data to be in the hands of people who might harm me, or even just harass me, or just send me stuff which is unwanted to me, or build a profile about me and then use that to take decisions about me. So I think all of this is something that can be regulated through a dedicated law, and that's what we have. And it is not to say that we didn't have a law earlier. I think we had this concept of data protection even earlier in India, personal data protection, but it's very limited to some sensitive type of data, and now it's much more broader. And the second part of this is it's also about privacy. So, okay, you may not do any harm to my data if you have it, but I don't want you to have it. So I should have the right. It is my data. So what it does is it establishes me as the owner of my data. And if you are processing my data, you don't own that data. You are doing it for a specific purpose and you are holding it on my behalf. So you are just a fiduciary. So I think it sets that equation very clearly. And that's the big reset when we think of this law coming into being, that you are processing data for my benefit, for my purpose. And I think that's what this law essentially tries to do.
Okay. Kamesh, now I would like you to come in and explain to us what are the provisions that would, directly impact users, and in terms of practical benefits, like it's written in law, but direct impact on users in terms of provision and practical benefits that they will get.
Thank you so much for the question. Just quickly coming in, like as you actually set the premises for the conversation itself, right? Like where you said like nowadays anything and everything that we do, like from haircuts to like calls and messages, ordering food, everything leaves a digital footprint behind, right? So one way of looking at this is it's great, right? Like, it gives a wholesome experience and accessibility and etc. and everything. On the other hand, this also like amounts to a lot of privacy concerns, like how Mr. Aggarwal was also pointing out. So like here, when it comes to privacy tackling itself, I feel there is it's a puzzle which has like two sides, right? One, which is the demand side, where as a user, as a data principal, we shall do certain things to protect ourselves, and protect our data. But we need to also understand that there is a lot of awareness gaps which are existing. So that is where I think the provisions or the bill comes from the supply side aspects, where actually though we are not doing much, the other side, the data fiduciaries, when they're actually using the data, they use it responsibly. They follow the safeguards.
I will interrupt you a bit, and we will have to first tell our subscribers data principles and data fiduciaries.
Okay, data principle is basically all of us, any users of a platform, for an example, and data fiduciary is basically the entities which collects the data. And also one more term maybe which will come in our conversation is data processors. They are the third party whom the data fiduciary transfers the data to process. So so just putting it there. So coming back there itself, I think this is the segue where the bill becomes very crucial, right? Like where from the supply side, though I might not be aware how my data is going to be used and and etc., you shall still follow certain amount of security safeguards and etc. And also you take the permission as Mr. Aggarwal was also pointing out, where it is also that we are giving the agency to individuals. I shall not give my data to everybody, right? And data protection is not a concept which means that you shall not share your data. It's also about where you share your data and with whom you want to really share the data, and how this is optimally used. I think these are the spaces where the bill comes in. It is very crucial, and that's where I think the impact for the users will really pan out to be.
Aparajita, I would like for you to come in now. Can you talk a little bit about how will this bill help common users control their data? What are the provisions? How do they control who they are giving their data to? How is it being processed?
Right. So, Yuthika, thanks for inviting me to the discussion, first of all. Second, I think generally at the very base of it, what this bill is doing is giving certain rights to us as citizens, right? Which is data principles. And these rights we can exercise to get more control over our data. For example, in our dinner table conversations, often there is this conversation that, I was searching for something online and now that's all I can see on my social media. How does, for example, Instagram or Facebook know that I want to buy a black dress, for example? Now, of course, people who work in this industry probably understand that there are caches and cookies and, internet knows a lot about you. Some of your innermost desires that people around you don't know. But I think for other people, it seems like magic. Like for many people, it's like magical in some ways. But I think the first right that we are getting is right to access information about our personal data. That who is it shared with? What are they using it for? If, for example, we gave some data to a platform, say Google or Facebook or Instagram or anyone, have they shared it ahead with somebody else? All of this information now we can get as a citizen after this law is passed. It's notified. Then we also get the right to correct and erase our personal data, right? So, for example, we may have given certain data at some point about ourselves, which wasn't correct, but it sometimes sticks to you. So you can actually ask a platform to go back and correct it for you. And you can ask them to erase it also. For example, I had made this really crazy Twitter account when I was maybe 15 years old. And, at that time, I was just posting stuff that I think I'm very embarrassed about right now. So if I want to ask Twitter to, or X, we should call it, to actually delete it, then maybe I will be able to ask them to actually delete it because I own that data. Third is that I have right of grievance redressal. So if a platform asks me for data for some purpose, but they are using it for some other purpose. For example, I logged on to an edtech platform just to do my coursework, but that edtech platform has now sold my data to, say, a bank to give me a student loan, and I never consented to it. So I can actually complain about it to the Data Protection Board. If there is a data breach, I can also do that. So, I can complain to the platform. If the platform does not give me the right redressal, then I can take it further. So that type of right also I've got. Fourth, there's right to nominate, which means basically if I die, I think a lot of people of our generation will have this problem. It will be almost like a will, because a lot of stuff about us is recorded in our, emails, in our social media. So who gets access to that? That also platform by platform, I can say that, okay, my husband gets access to this, my mother gets access to this, etc., etc. So I think those are the 4 rights that you're getting, which basically means that you have more control now on how your data is used. I think we'll discuss this a little bit further. Is everybody able to access these rights in a country like India? That we can discuss, but this is the baseline that the bill is setting.
Sure. So before I get to more of my questions, we already have a question from a subscriber. So I would just put that out for panelists. This is from Rishikesh Prabhu. They are asking what would be the retrospective impact of this bill, or it will consider data privacy from a point in time, especially that a lot of businesses already have our information now. Up for any panelists. Anybody who wants to take this.
Okay, so I think obviously a lot of businesses have collected data for a lot of people, and what this law says is that you need to make sure that you get a consent from them afresh. Now, obviously, it doesn't go at the law level to say that in what time frame and how. It leaves that something to be worked out, but it puts that obligation and more. I think in addition to that, like I think Aparajita mentioned, you can actually ask any entity who's processing your data to get summary of the data that entity is processing. So in that sense, it's not retrospective, it's prospective. But the way it makes sure is that it doesn't leave a gap where you say that, okay, just because I've collected your data, you don't have a right of protection for that data, because that would not be the intent at all. So I think it strikes that balance. And so that's my understanding.
Would there be a way users will be able to see at one place who all have their data, and if not what they're using it for? At least we give our data so openly in India. So is there a way to, like for mutual funds, you can go to one place and see what mutual funds you have invested in. Would there be a way that we can see what are the places we have given our information?
So I don't know whether we would want that, because that also could mean that you have all your data at one place for some reason. But I think what is envisaged is that you can manage control of your data in a simple manner, and which could be through if you imagine it, it could be just like an app where you have all these buttons, which is saying, okay, these are 20 companies, and these 20 companies each are using your data for 5 purposes, and you have this right to just swipe left or right and stop people from using certain data for certain purposes. So which is really having control on your mobile, so as to say, to manage your data. But the data will not be at one place. The data will be at each of the entity who have acquired the data for the purpose for which you have consent or I have consented to. So I think now this is very interesting, because we often hear that, okay, when I'm actually on the internet, or when I'm doing some transaction, or I'm generally, interacting in the context of my data, I don't have the time or the bandwidth to try and make sense of these terms of contract or terms and condition, which just, so I literally, even if they want me to read it, I will scroll it to the bottom and say, click. Now, that may be so, but I think what this consent manager does is that you then still have the control to be able to say, okay, fine. Now I don't want to continue with this consent, so I'm able to withdraw it. So I think what the law specifically says is that it should be as easy to withdraw my consent as it was in the process of taking it. And I think that is something we'll have to see how it works out. But this consent manager in the law is a little bit of a uniquely Indian proposition, which I think is very good from a consumer point of view.
Okay. We have another question from a subscriber, Prerit Soda. They say, in the EU, we have company-specific data protection officer and country-specific information commissioner officer. Does this law bring in such authorities in India too? Plus, will such authority be part of central government or states?
So yeah, maybe I can come in here a little bit. Is that like I think that's like one of the unique differences that India has, is that we are not having any authorities. So we will have a data protection board, but it's an adjudicatory body, and it's not a authority like a data protection authority, which is there under the GDPR or the most of the data protection legislations out there. And secondly, just talking about how this process works. Also, I think like one more thing is that the appellate tribunal concept that the bill has brought into the picture, where like the telecoms appellate tribunal TDSAT will be the person where you can actually go to the appeal the whatever the judgments the data protection board has actually given. So these are like the two important bodies I could actually come up with within the Indian version. Secondly, coming to the second half of the question about the state, right? Like that's still a question that like what's the role of data protection? What's the role of the state governments within the data protection? So at this moment, I guess like it's more on the central side. The data protection board is also central, and it's digital by design, so it's not literally central to say, but it is still like formed by the central government and etc. and stuff. And the rule making is also with the to an extent with the parliament and as well as with the central government. So how the center state within the quasi-federal structure of the Indian constitution will have to see, and how those frictions can be weeded out is something that we have to see as we move forward. Yeah.
Sorry, I just want to add something. I think there was a little bit of confusion in the question, because I think the word authority was used, but I think the question was also about whether companies will need to appoint a data protection officer. So yes, the companies will also. While Kamesh is right that data protection authority, there's no data protection authority in India which is going to decide the rules, etc. So it'll be Ministry of Electronics and IT itself, but I think at a company level, yes, there will be a data protection officer for significant data fiduciaries, which means bigger platforms which are above a certain threshold in terms of number of users and revenues in India and their size and scale. Basically, these data protection officers will be the first point of call for any redressal that a user wants when it comes to any problem they have with with any platform. So yes, at the company level they have. I also think, by the way, even though government has gotten exceptions, ground to get exceptions, I don't foresee that all government entities will make use of that exception. So they have to specify when are they using the exception. It's not by default that all government entities have exception. We've also been talking to some people in the government itself, and they themselves are thinking about how they need to change their processes, etc., as data fiduciaries. So while the government may certain times take exception in the name of national security, etc., but in many cases, it is wherever it is a data fiduciary, it's already asking for consent, right? For example, if you sign up for Digi Yatra, you have to consent to some consent notice, which I also haven't read properly. That is the problem with consent. But the point is that it's already complying with certain things. So many government entities may also, if they are a significant data fiduciaries, for example, I imagine all the public sector banks, they will probably be significant data fiduciaries, and they will probably end up having data protection officers as well.
Okay, that is very good that we are getting more and more questions. Please keep your questions coming. We have more questions. A subscriber has asked for fresh consent. Would there be some kind of check for big tech companies so they don't block free services unless we accept their data collection storage? Something what Meta did a couple of years back and then backtracked. I think it's open for all panelists.
Shall I take a crack at this one also? Okay, so see, I think it's we don't know in the short answer in terms of how it will play out, because some of these things will play out. But if we were to look at it in a very just from a point of law, there are two concepts, right? One is purpose limitation and second is data minimization. So today, when somebody asks you for a broad consent, saying, I need your data for processing and that's it, and one take it or leave it. So I think that regime is untenable in this new law. So the purpose has to be clear, unambiguous, specific, so on and so forth. So when you go in this kind of a framing, then it is up for the data fiduciary to therefore have this position to say that I am not able to provide you service because you have not consented to this while my consent requirement met all this criteria. So if that were so, then yes, I mean some services probably cannot be provided. But a scenario where a company had a very broad usage and was giving a take it or leave it deal for the consumer, I think that era is gone. So from that point of view, I think it should be a huge progress. Yeah.
Okay. So I'll bring in one question from my side. I actually wanted to get all three of you in for this. Data protection bill has been in the making for like 6 years almost. And every time a fresh draft has come in, even with this law, there has been a lot of controversy around it. So for all of you, can you give me like 1 point or two if you want, what works for you in this bill and what doesn't work, what should be looked at and what is very good with this bill? Aparajita, do you want to start?
Okay. I think this bill is definitely industry friendly, I think, because it's not very compliance heavy, which I think is good for ease of doing business in general. And also they have specific carve outs, for example, for startups, which is good for India, which has a very vibrant startup ecosystem. I also think there is some innovation as well. For example, the consent manager is a good innovation. Given that we are building all this digital public infrastructure, it might be a good experiment for us to see whether people are actually able to manage their consent across platforms in an easier way by making an interoperable sort of like system, which Ashish was alluding to earlier, which is a central app where you can just see where all have you given consent. And I also think it's good that there's a grievance redressal system is supposed to be digital, so you don't have to go physically, like, courts, etc. So that might help more people actually access that entire system. I think in terms of negatives, I am very troubled by the fact that, we don't have a DPA, Data Protection Authority. I think it would have been good to have sort of like an authority which is at a one arm's distance from the executive itself, because it has worked well for us in the past. For example, try regulator is, a good regulator which brings in a lot of specialization. It's very transparent, very consultative in the way it works. So I think that we should have learned from that experience and maybe implemented it in this, because now we already have experience with these quasi regulatory authorities, etc. So for me, that is a little bit disappointing, coupled with the fact that data protection board itself is very much under the central government now. Now, in this situation, what happens is that as a citizen, for example, when my COVID data got leaked on Telegram a few days back, would I feel comfortable as a citizen going to the DPB and complain about it? I mean, just that I guess the power equation changes quite a bit when you know that something is very much under the central government itself. And the last thing, sorry, I know you asked for two, is something that I am really passionate about. I think children's data privacy, how it is tackled in the bill, I feel that is something that unfortunately we have not discussed enough. And we have taken a very, very paternalistic, out of touch kind of approach to it. And it will not just impact children on how they access their data, it will impact everyone. Because to determine who is a child, age verification needs to happen for every user on every platform. So I actually do not understand how will this get implemented if we go by what the law says right now, given that it's very strict on verifiable parental consent. So
but it also mentions for some, in some cases, the age limit can be relaxed.
Yes, if a platform says they're verifiably safe, but will you go platform by platform? Will you go by categories of platforms? And then if you go by categories of platforms, what is an edtech platform? Would YouTube be a edtech platform? You may categorize it as social media, but I can tell you I work in schools. YouTube is the biggest edtech platform. So how will you actually do that? You wanted to have a blacklist approach, but we ended up with a whitelist approach, and I don't think it's very feasible.
Okay. This is something that we will take up again, children's data. Kamesh.
Yeah, so just like, coming in itself, like before passing any value judgment on the bill itself, is that like it's a good start. We did need a bill, and we have a bill, so it's like something we have like now, and like we have to build progressively. So coming in with like certainly like obviously some of the sticking points from the previous versions of the bill, like the across, has still lingered, like which one Aparajita also pointed out, which like age of consent is very high, and like and like how are we actually like going to like operationalize it is still a problem. And like one point that she also mentioned is that like how are we going to like even bring those class differences, right? Like also like what do you mean by like verifiably safe? So what are those parameters? And also like some classes of data fiduciary will also be exempted from these additional obligations, which is also like we don't know what kind of data fiduciaries that would be and for which purposes it would be. Certainly like, so, and then like one more thing which is like lingered for a long time in the bill is the state exemption. So, the state exemption is still in the same format where like, checks and balances for the proportionality is like, not unaddressed. And the third thing that is like, something very new the bill has brought in, which is like stands a little bit like, if we can call this as a sticking point as well, the power that the central government has given to themselves, which is the clause 36 and 37. One is that they can seek any information from the data fiduciaries or intermediaries or the board itself. And the 37 is generally like speaking about the content blocking. So, so how these like, also going to pan out is something that is like, we will come to know over time. With that, like also generally speaking with the bill, I guess like, most of the things within the bill will pan out in the course of time, because we need more directions in forms of like notifications and rules which will like subsequently come. So I guess like there we will be like deliberating a little bit more in terms of like how are these aspects which has been spoken within the bill will actually operationalize. So these are like the certain points that comes out, and like data protection authority, right? Like there has been we had a data protection authority in the previous versions, and like in 2020 version since then, like we don't have it. So, and this also has like concerns with like where Indian bill stands in the global level, right? Like, so, like the two major things which comes within the global level itself is one, like we lack a data protection authority. Second is the exemptions. And specifically within the exemptions is that like we exempt the foreign data which comes into the, the nation, the same protection that we get. Finally, like, one way I can also say, like, because you asked for the like overarching thing, like one thing that has like, like maybe also an advocacy success is that is about the data localization aspect. So we started somewhere like, very stringent data localization towards like an aspect where it is more relaxed at this moment, where like we move towards where the data can flow to any country, but except like to the countries which the government will notify. So there also like we have a little bit of like, clarity needed, right? Like how are we going to like even make this negative list of countries? Like, and also we don't know like what are the mechanisms that people can follow in terms of the cross-border data transfer. Plus also like we have the sectoral regulations which has been given that like particularly for the cross-border data transfer, the sectoral regulations can apply. That means like RBI already has data localization for payments. IRDA already has data localizations, and like a lot of people have like data localizations for certain data. So we really don't know how these things are going to interact, because like when it comes to implementation, there is a conflict, and like how are these going to interact is something that is like, one has to, wait and watch.
Kamesh, you talked about state exemptions, and I just wanted to elaborate a bit on that. So government says that there will always be some exemptions for them. National security, sovereignty, everything. There in every law there. In this kind of law, what are some of the safeguards that can be built to sort of balance the powers that the government get, but not absolute powers?
So like two things here, right? Like, definitely like before moving to those two things is that like, definitely nobody is denying there, like, there's a national security and the state interest where the state has to be exempted in certain aspects. But the problem here is like, the two things that is needed here is like what are the determining factors for considering which state authority, state authority or the state body that you will actually like, exempt, because that's super open-ended, and like, central government can come tomorrow and say like any entity, right? So like we need that, the proportionality. Like, what is the mechanism that you are going to follow? Secondly, okay, now we are exempted. When you're exempted, what are the rules that you will be following? So certainly, like in the deemed consent aspect, now it is called the certain legitimate interest. There, they've actually brought that, like if the state is being exempted for the purposes of subsidy and etc., they shall follow certain rules. Like, when they're doing that. But we don't see the same within the clause 17, which is the exceptions. So we don't know, these are like the two things that could make it better. Nobody's denying that we don't need an exemption. We do need an exemption, but like it has to be done in a mechanism which is accountable, transparent, and, we can also like, hold and check. So yeah, I guess that's where it comes.
Ashish, I'll bring you in, but I want to continue on this point. There are also exemptions that government can give to private entities. What do you have to say about that? Like, they have included startups, which is a very wide-ranging definition as well. So
I think at a design level, this differs from GDPR because it treats the risk-based regulation in a different way. So you have this significant data fiduciaries where you have additional obligations. Then there is default for everybody else, and then there is scope for exemptions. So I think it doesn't undermine protection by design. Some of it, we will see how it pans out in terms of rules. I'll take one example out of what Kamesh mentioned on this particular point, right? So processing of foreign data in India, right? So India, the IT industry processes data of over 120 odd countries in India. And it's been doing that now for 40 years. And broadly, it works well. It is based on strong contractual arrangements and so on and so forth. So one of the objectives of this law is that how can it further strengthen this data protection? Now, we went into the debate and it could have panned out two ways. One, we could have applied a wholesale law on the entire foreign data, right? The full law. And then what that risks is that there could be incompatibility between how the host country law applies to this data which is getting processed here and how our law applies. And we didn't want that incompatibility or a bit of a gap. So what's the balance? The balance is that if you are processing data in India through a contract, that means you're not just processing it in some illegitimate manner, you already have a contract, then you will still be required to follow security safeguards. So that means that all the security safeguards which will be specified under this law will apply. But then you don't have to necessarily, comply with all the rest of the provision. So in some sense, it's a good balance to say that, you are enhancing data protection for foreign data also and allowing because GDPR anyway applies to that data being processed in India. And now it's giving you a legal recourse that if the security safeguard doesn't apply and there is a data breach, and then our data breach definition is also unique. Because we don't talk about breach in a traditional sense that, okay, my data is stolen, but any authorized processing is a data breach. So that means if I have processed the data in a manner which I was not authorized to do, it is a breach. So in that sense, I would think that it is still a very good position. And what it does is that it avoids the complication where jurisdiction can be splitting here over, this is what I need you to do as per my law. And then the company is struggling that, okay, this is what I'm supposed to do as per this law. So from that point of view, I think the exemption bit overall is fair. One part where I will agree with Kamesh is that when you think of the state exemption, I think sometimes it can be a blind spot for the government to say that, okay, we are anyway for the welfare of the citizens. So when we are having exemption, we will do everything smoothly and nicely. But I think this concept of just, fair, reasonable, and proportionate as a test for an exemption is, if it was encoded in this law, it would have added that much more confidence. But again, you said this law is like 6 years in making, but depending upon the perspective of the people who have been it, some people will go back 10 years. So, and there's nothing called a perfect law in my view. So I think what we have is something which doesn't have a strong where we say oops and not a starter. So I think we have a good thing to start with. And in some sense, it avoids the entire upfront cost of compliance, which let's say the GDPR imposes across businesses. And we are trying to be smart about it to say that, okay, fine, we will put the obligation, but not something which could actually increase the cost of business substantially and disproportionately.
Ashish, since you were also comparing a bit to GDPR, we also have a question from a subscriber, Siddharth, on how do we compare it with policies such as GDPR. So anything you would like to add on that and bring in other maybe international laws, and how does our law compare?
So I think it will be too much time to try and do a comparison, but I think at a fundamental level, building on what I said, that this is a law for India. So from that point of view, it is not taking the European context where you have very strong legal systems and all of that is set. So you have very strong, let's say, capacity in terms of regulating and enforcement. So what we want to do is we want to be frugal but yet effective. So from that point of view, our law differs. But at the same time, we are also harnessing technology very well. So, for example, one of the big thing about this law is how it thinks about complaints handling through the redress board. So, in a very in the perfect scenario, what we should expect is a lot of people should feel and find it very easy to complain and get a very quick resolution, whether it's through a chat or through a telephone or through just a message where there can be quick online taking on board of complaint and disposal where corrective action can happen. Because typically what happens is people don't complain because it is just too onerous to complain. And that's what we want to avoid from this law. Second thing is that this entire idea of consent manager, I think it's something which is uniquely Indian in some sense. And that should really allow for people to be informed about what they are consenting to. So from an overall perspective, I think I wouldn't see this as a comparison between which is a good law and which is a bad law in that sense. But is it a law which is suitable for India? definitely. Does it mean in a global context, our law can stand up and say that we have a strong data protection law? I think we can say that. While I would agree with Aparajita that, okay, having an authority would have been nice, but then that is also something that we need to see. How does METI actually take this forward? So in some sense, some of our apprehensions are forward-looking apprehensions where we naturally worry that when the state is also an actor who is potentially a party to some of this, then how does it also create a data protection, this board? And now they say in the law that the board has to be independent. So again, if they do create it independent, then I don't think it's a problem. So I think some of it is just ahead of us. It's too early to therefore come to some kind of a very finite judgment that, okay, this is something which is necessarily a problem. And from a global point of view, I think it's good that we now have a law, and we'll have to actually see the next 2-3 years. And even for GDPR, I think we are not in a journey where we can actually today, after 8 years of GDPR, come to a decision and give it a kind of a report card where we say, okay, pass, excellent. And so I don't think we have that kind of a time frame yet.
We have one more question which also relates to GDPR only. Ashish, we want to take it. GDPR has arrangements on companies collecting personal data of employees to, like, setting up of workers' council. Any such provision in our law?
Not on the face of the law. What the law says is that for the purposes of employment, you can process the data. It is part of the legitimate purpose. Now, it is anybody's guess that as part of the rules and guidances, will the government come up with stuff? It can. So I wouldn't be able to comment beyond that on this.
Okay. We are almost out of time. Before we close this, I want to, there are a lot of questions that I had, but I want to close this on what we started with, Aparajita started with, rights of data principle. We talked about consent in that, right to forget, and how in implementation terms, how easy or difficult it is. Even if we talk about right to consent, that you have to give consent, there are innumerable apps that we use, innumerable websites that we go to. Forget about offline world, even in online world. Do you think it is implementable, and what sort of tech will go into it? I would like all three of you to come in. One man.
Maybe Aparajita, want to go first?
Aparajita, you're on mute.
Okay, I can go first. So basically, I think, I've been saying this to everyone that this is the easy part that we've got done now, which is actually having a law which gives us these rights. I think the hard part starts now, that how do we get this information out to all our citizens and to all, which means that, every single person who's using a smartphone or internet in this country, which is basically people in like the remotest villages of our country, so that they actually understand what they're signing up for. And I think one of the criticism of taking a very consent-based approach, which we have ended up taking, is that there's a lot of consent fatigue, right? I mean, I just told you that I was signing up to something and I haven't read consent. I work on this, this is my daily bread. But when I'm in a hurry, I don't have the time to read through this. So one thing is that the law does say that notice has to be in 22 languages. It needs to be in, it needs to be itemized, and it needs to be in a manner that it's understandable, etc. But I do think that even then the consent fatigue is real. Consent manager can help with it. But I think the knowledge that these rights are there is very important. So what actually I have been advocating for is, just as we read about our fundamental rights, now this should be a part of civics curriculum, right? Because all of us are data principals as well. Yeah. And every person should know that these are the 4 rights that they have as data principals, because our very important part of our life these days is our relationship with technology. I mean, the amount of time we spend with our phone is actually more than some of the people in our lives as well, right? So I do think that it needs to be now integrated into the curriculum, so that now people understand from a very young age that, they have, if they are online, privacy matters and how it can also lead to certain harms, etc. So one thing that a lot of people say is, oh, I have nothing to hide. But that is a very big fallacy. It's you have nothing to hide until the time you get caught in some kind of mess and you realize that things that you were doing online, you should have hidden them well. So I think that is something that we now need to do. Like the education part of this is also as important. And it is true for every law, not just for this law, right? Once a law comes and it gives some kind of right, for example, right to education came, you had to educate communities that, now your children can actually exercise that right in school. So it's a similar journey that we need to follow with this bill as well.
Kamesh, next to you. If you want to add something, these will also be your closing comments. We are way out of time now.
Okay, so sure. I guess I'll quickly come in and give the what are the question that you asked in terms of the rights and etc. and how the technology can also be one of the levers through which we can actually do this. So quickly, coming in there is that we also have a emerging startup or the emerging sector called the privacy enhancing technology sector, which actually tries to help both your businesses, which is your data fiduciaries, and the data principals, which is us, in terms of protecting our privacy. So just giving some examples itself is right. There are as Aparajita was mentioning, it's my bread also to do privacy and data governance as a day job. But sometimes it's consent fatigue is real. And also sometimes you can't read these languages and they're sometimes super encrypted for us to understand what it is, right? So, but there is also the expertise problem comes into the picture. How much ever you do come to know that these rights are there for you, unless you don't understand what is particularly given in the notice, it's of no use. So that's where I guess there are technologies which can aid you, which will actually read all of these privacy policies for you and put it out simply as a pop-up when you're entering certain places, and then you shall give your consent. And one of those privacy enhancing technology which Mr. Aggarwal was speaking since the start is the consent managers, who will be the one who's conduiting between the information seeker and information provider, where they will come as in between and give such consent for you. So certainly that we need to see how technology can aid us in this. And secondly, on the other side is of the supply side also, right? Certainly within India at least, data protection or privacy protection and etc. is super new. Especially if you go to MSMEs or startups or etc. For them it's one more new compliance that they have to do in addition to multiple things that they do with the resource constraints and etc. There I guess again technological plugins such can help them in terms of easy compliance, in terms of complying to certain aspects, in addition also pushing the needle towards a privacy centric culture on the long run. So I guess that's where we will be needing a little bit more attention moving towards, because certainly this industry has existed for long in other jurisdictions where the data protection legislations have existed, but in India I guess it will it is there, and it is going to evolve as we move forward with more of these conversations.
Okay, thank you, Kamesh. Thank you, Ashish. You have
So for the law to succeed, I think we need both the carrots and the sticks. So we talked about carrots, education, awareness, all of that. I think we can go up to fines of 250 crores. We can even block a business based on, if it doesn't mend its ways after multiple warnings and stuff. So I think a combination of both will set the tone for this law to be effective. And it will take about a year or two to get this started. So that's a good time to do this awareness. It's a good time to build expectation both for the industry and also the rights of the users. It's a time to set up a very strong board. It should be like a BPO in my mind, where hundreds of people are sitting looking at your complaints and very quickly resolving them in some ways. So I think that is something that will stand good for the consumer.
Sorry, one last thing, if I just can add to Ashish. I also think that, eventually with every law, citizens always have limited time and limited bandwidth to actually go through these things. But eventually a civil society also kind of takes root to actually see, whether these big companies or data fiduciaries are actually complying with the law or not. So I do think, for example, now there is so much activism around, these annual general meetings that big tech companies have, etc. This will also happen in India now, because there will be an invested civil society, and we have a vibrant civil society, which will actually study these, notices in detail. So I think the incentive now is to the platforms to actually do right by users. And I think that is the most important thing. All the carrots and the sticks, come into play when things go wrong. But I think if you change the intention of the entire ecosystem to do right, which I think this law is trying to do, I think it shifts the entire, situation, which we are hoping that this law will do.
Just quickly coming in there, like one small point is that like as Aparajita mentioned and like Mr. Aggarwal mentioned, is that getting the right message out there, right? Like, it's not certainly like always like we can't like paint like data protection legislation as another compliance burden or like something that is imposed on the data fiduciaries, right? Like actually, like if you see it from the long run, which has also been like, certain researchers and research points point out that like this like kind of like builds the trust over the solutions that like the data fiduciary is providing, that eventually also comes back as a competitive advantage and a market benefit for the data fiduciaries themselves. Maybe at this moment, maybe we will be doing a little bit of hyperbolic discounting because like there's going to be a cost involved with the compliance, but in the long run, it's going to reap the fruit. So I guess that right message has to be like, gotten out clearly such that like, we are as an ecosystem, we are evolving towards moving towards a privacy-centric culture.
Great. Thank you. We are really pressed for time now, and we have to close this session. Thank you, Aparajita. Thank you, Ashish. Thank you, Kamesh, for joining us. And thank you to all our subscribers for joining us. It is because of you that we are able to do the journalism that we do and bring you such sessions. We welcome your feedback. Hope you liked it and hope all your queries were answered. And with that, we will close this session. Thank you so much.
Thank you. Thanks,
Thank
Yuthika.
you.
Thanks.
Bye.